this is Nitin here. In this video, we will be learning about arbitration. So the aim of this video is to learn the practical aspects of arbitration. So first of all, what is arbitration? So arbitration is a process by which parties refer the dispute to a third party for adjudication. In arbitration, instead of going to traditional courts, parties refer their dispute to a third party who may have a specialized knowledge to resolve their dispute. So the basic advantages which are associated with arbitration are that it provides flexibility and autonomy to the parties to choose their applicable laws, procedures, etc. So parties mutually decide among themselves the applicable laws, procedures, the number of meetings, the duration of the hearing, everything, etc. Secondly, parties are free to decide the seat, venue, applicable laws, etc. So suppose there are two parties from different nationalities. So parties themselves can decide the applicable laws, which law shall be applicable to their dispute, the venue, that is the supervisory jurisdiction of which court will be applicable for any assistance which may be required during the arbitral procedures, etc. And thirdly, these institutions are neutral, so it prevents them from any bias that may arise during the arbitration procedures. And fourthly, the award passed by an arbitral tribunal is binding on all the parties to the dispute. So it means that tomorrow a party cannot say that this award is not applicable to them, and an award passed by an arbitral tribunal can be enforced in the same way as a decree of civil code. So it gives a sanction to the procedural statutory sanction to the arbitral procedures, and any award passed by an arbitral tribunal is very much confidential. So parties, because of these advantages, prefer arbitration rather than going to traditional courts. So there are two types. Basically, there are two types of arbitration. First, the institutional arbitration, and second is ad hoc arbitration. So institutional arbitration generally have their own sets of rules, regulation, administrative body, etc. So they provide the assistance to the parties having their dispute for efficient dispute resolution. On the other side, the ad hoc arbitral tribunals are where the parties themselves have to decide the applicable rules, procedure, the arbitrator, etc. So some of the famous arbitral institutions are Singapore International Arbitration Center, Dubai International Arbitration Center. In India, we have the New Delhi International Arbitration Center, etc. So basically, so the next question that arises is, what types of dispute are arbitrable? So every civil and commercial dispute, be it contractual or not contractual, unless expressly barred by any statute, is arbitrable, which means that any dispute relating to right of persona, that is any dispute which arises from any relationship between the two parties, is arbitrable. I hope this video was helpful, and in the upcoming videos we will be learning about drafting of arbitration clause, the essential conditions of arbitration, etc. Thank you.